Good afternoon. Welcome to Professional Judgment Did You Know? This is the first time we've had a professional judgment session at the FSA training conference for as long as I can remember. And we can see by the crowd and the large room that you were anxious to attend the session as well. So we want to thank you for being here. My name is Annmarie Weisman. I'm the director of the Policy Coordination Group in the Office of Post-Secondary Education. I have with me here my co-presenter, Bruce Honer, who is a training officer in the San Francisco Regional Office within Federal Student Aid, and we are very glad that you're here today. We'd like to remind you that we will be taking questions at the end. Because we're in such a large room and the sessions are being recorded, we ask that if you have a question, you proceed to one of the 4 microphones, numbers 1, 2, 3, and 4. The microphones that we're using for this specific session are labeled with a number. If you see a microphone that does not have a number, that is for the next general session. Keep in mind that because of the topic that we have, some of the questions that you might have might be very specific to specific situations that are difficult for us to answer. And when I say difficult for us to answer, that's because you do have a lot of latitude with professional judgment. So while we'll do our best to answer your questions, we may have to throw out that generic "it depends" response that I know is very frustrating at times when you want the answer. But as we go through the session, you'll see, if you don't know already, why that is the correct answer because of the way professional judgment is handled. And again, we'll remind you of that as that applies, but just keep in mind that many times we can give you some ideas or some guidance, but we won't be telling you this is the way to do it. And I know that makes some people uncomfortable because it's a bit of a diversion from how many of the answers are, where it's this is what you need to do to be in compliance. But we'll give you the best guidance that we can, and we'll remind you many times throughout the session, I'm sure, and through the questions, that we are giving you guidance, not so much of a requirement. We also want to remind you that the evaluations will be emailed to you after the session, after the conference, and that we do hope you'll take the time to evaluate this session and let us know, again, if it's something you want to see again by your ratings and by your comments and feedback. Bruce and I are also available for follow-up questions after the session. If you get back to your campuses and you think of something that you meant to ask or something you didn't want to ask in the large group, our email addresses and phone numbers will be at the end of the session in the contact information. Just going over our agenda fairly quickly here, we want to give you an overview of professional judgment. We'll discuss how you would adjust cost of attendance as well as EFC data elements, and then discuss the difference and why you might want to do one versus the other, why it might be helpful to adjust cost of attendance versus EFC in a particular situation. Bruce will also be talking about performing a dependency override, as well as parent refusal to complete a FAFSA and to provide support, and then denying or reducing direct loans. Because my role is typically in the policy area, I'll be doing the professional judgment overview, and Bruce, who works more with the operational aspects of things, will be covering those topics. We use the term professional judgment a lot of times as we're talking as financial aid professionals, and we want to remind you that professional judgment is not something that the department regulates. While the term is within regulation, there are no regulations for how to do it. So we don't have a how-to manual on professional judgment. The term is not found in the law, although statute guides professional judgment as a practice. The Higher Education Act reminds you that you have the authority as a financial aid administrator to make an adjustment on the basis of documentation provided to you to allow for the treatment of an individual that has special circumstances. And I think that while special circumstances is the real key words here, you also want to remember the word individual, and we'll talk about that as we go through the presentation as well. You want to remember that you are doing a professional judgment on the basis of individual special circumstances, not special circumstances that might apply to a group. And again, we'll talk about that more as we process through the presentation to kind of remind you of how you might want to do that if you have a group of people that have what you see as a special circumstance. The Higher Education Act in Section 479A gives you the information you need in terms of how to do a professional judgment. And while I am typically not one to read to people, I think it's really, really important that you understand where your basis for professional judgment comes from. And so I do want to read to you very briefly from the law. The Higher Education Act states that nothing in this part, and again that's part 479A, shall be interpreted as limiting the authority of the financial aid administrator on the basis of adequate documentation to make adjustments on a case-by-case basis to the cost of attendance or the values of the data items required to calculate the expected student or parent contribution, or both, to allow for treatment of an individual eligible applicant with special circumstance. So again, looking at what we're going to cover today in our session, Bruce is going to be taking you through how to make adjustments to cost of attendance or the value items that are part of the EFC, for, again, both the student, the parents, or one or the other. We, again, want to remind you, and again, very repetitive here, but very important, we're talking about an individual special circumstance. So as we talk about that, we want to remind you of the latitude that you have. We also want to remind you that there are times that you are not able to make a professional judgment. Something that you might do could be seen as an unreasonable professional judgment or an unreasonable determination. So we want to go over that with the idea of not doing anything that is contrary to what you heard in the law. You also want to keep in mind the following things in terms of what it can't be used for. But I do want to think about that idea of what's contrary to the law. The idea of special circumstances is a fairly easy one to figure out for most people, but sometimes people will come to you with ideas of what they perceive as a special circumstance, and we would say that they are not typically things that we would allow. So as an example, somebody who says they have significant credit card debt. In some cases, that could be a special circumstance. In other cases, it wouldn't be. And what I would always advise people to do is think about what is behind the credit card debt. So are they going out and they're charging co-pays and co-insurance for medical expenses with their credit card? Or are they accruing consumer debt? That is, I like to shop, and so I have all of this debt. I have a lifestyle that I'm trying to support. Certainly medical expenses, one would say, is a very reasonable professional judgment. But then if you look at the idea of supporting someone's consumer debt and their lifestyle, that would not typically be seen as something that is reasonable. So we'll talk again as we go through about things that are reasonable, things that are not. We want to remind you of some things that we've determined are not appropriate uses of professional judgment. We want to remind you, for example, that you can't directly change an EFC. Those who have been around a long time might remember that there was a time when you could change an EFC. I wish I could say I wasn't around that long, but we won't talk about that. So you also cannot make changes to the formula, and that's where we talk about circumventing the law. We wouldn't want you to do anything that is contrary to what the statute intends, so we're not looking for you to make a judgment that, well, the statute doesn't allow for this, but I think it would be a good idea. Or the EFC formula doesn't allow for this, but I think it should be included. There are certain things where it's reasonable to do that with, and we've talked about examples throughout the years. One that comes to mind, for example, is private school tuition. Some people believe that private school is something that they need to make as a special circumstance. Sometimes people will come to you and they'll say, well, in my community, my son or daughter has a special need, and so we paid for private high school tuition so that they could get the services that we needed, and we'd like that to be included. And you may decide that that's reasonable for you. But there are other things, and again, the consumer debt is the one that comes to mind often for me, that somebody who takes a vacation every year and says, well, that's very important for my family. That's not something that we can support. That goes contrary to what the formula would allow. We also want to remind you that professional judgment is award year specific and does not carry over from year to year unless you're going to get new documentation and that another request is made. So again, there are certain things that you would look at and say, for this year, that's reasonable. One that comes to mind quickly is unemployment. If someone is unemployed and they're still unemployed, we say that doesn't technically carry over, but it's a reasonable determination that you might make to say, if the person is still unemployed, I'm going to get additional documentation for the next year and grant it for the same reason that I did in the year one. So when we say that it can't be carried over, what we're saying is it can't be automatically carried over. You can certainly make the same determination 2 years or 3 years or more in a row. The one that I alluded to earlier, to me, is very important, and not establishing automatic categories of special circumstances and providing identical outcomes to all students in that circumstance. And let me give you an example of this one that I think is really telling. We were aware of a school that was in a community, a very small town, where mining was their main industry in that town. So when the coal mine closed, a lot of people became unemployed. And the financial aid administrator contacted the department and said, we believe that this would be an exception to your idea of providing everybody the same professional judgment, because it hits everybody. And what we said to that person was, well, it may hit everybody. It may hit many, many people in your community. And if you have a group of students where you can say they all had parents who worked in the mine and they're now unemployed, that's a reasonable determination that you would say they may need to be candidates for special circumstances and adjustment. But you'd want to look at each person individually, because you don't necessarily know how it's going to affect the family just because one person is unemployed. Certainly, if the person is a single mom and they worked at the mine, you can say, well, then there's no other income for that family from another parent or from that person. However, you want to think about the person who worked at the mine and had a spouse that might have been the vice president of the local bank. That person may not need professional judgment. They might, that's not to say that they won't, but it's something that you'd need to look at, and you can see where those two families might be impacted very differently. So we're not saying that you can't still do professional judgment for everybody, but what we are saying is you need to look at them on a case-by-case basis, and that even if it appears that they might all have the same outcome, there could be nuances in there that you would need to pay attention to in order to make your determination properly. We also want to remind you that you are not able to waive student eligibility requirements. The student eligibility requirements are there, and they are an essential part of determining who receives Title IV aid. So the idea of saying that somebody has to have a high school completion status documented, for example, you can't say that you're going to waive that. If males are required to register for selective service, as they are, you can't decide that you're going to waive that requirement. That would be going against the law, and circumventing the law, as we mentioned earlier, is not permitted. You also cannot use professional judgment to make an otherwise independent student dependent. We have had people ask to do that, and that is not permitted as well. Dependency overrides, which Bruce will go over later, is a one-way option, and that goes from dependent to independent only. And again, you're overriding their dependency, so it does not work in the other direction. And again, Bruce will go over that in detail later. You cannot make a dependent student independent based solely on the student's demonstrated self-sufficiency. Again, this is one where over the years things have changed. This used to be permitted, but it has not been for many, many years. Years ago, when I first started at the department, I worked in program review, and the first program review that I did, we had almost everybody who was a dependent student, they did an override and made them independent. And their reason that they documented was the same for everyone, that the student was self-sufficient. And again, although that was many years ago, it was still many years after that had changed. That is not permitted. You would need to document why the student should be considered for a dependency override. In terms of documentation, we often tell people that you can never have too much documentation. It's very helpful to have some reasoned basis for your decision, and the documentation is your key to that reasoned basis. So the Higher Ed Act uses the phrase "on the basis of adequate documentation." And so there's no definition for adequate documentation. As I mentioned earlier, we have no regulations related to professional judgment. But you want to be able to be convincing to someone else I always recommend that schools do an independent review of their records every so often, kind of an internal audit. If somebody else at your school looked at your records and said, is this reasonable? Do I agree with what they did? Or do they have enough documentation to support it? You would want them to be able to say yes. That said, we wouldn't want you to box yourselves into a corner. So years ago, when I was working in a financial aid office, I wanted to be very good, and I wanted to have all my policies updated, and I wanted to have all of my decisions be good ones. And I didn't want anyone to ever be able to question anything that I did. So I wrote a policy that said somebody had to produce 3 forms of documentation. And I thought I was doing the very responsible thing until I had somebody come in who said, 3 forms of outside documentation? I don't know what third parties I would get to document my situation. It's been something that we've kept very private, and we don't talk to clergy members or people at my school that would know. And so they were really struggling to find third parties who could talk about their situation. They ended up getting neighbors and relatives, and as I looked at it, I felt like compared to what my policy said, the documentation I had was a little flimsy. So I would caution you against being too hard-lined with yourselves and boxing yourselves into a corner that you can't get out of when you see that there is a reasonableness to a student situation, but maybe they don't have 3 forms of documentation that can be on letterhead. A signed statement shouldn't be the only thing that you rely on, but in some cases, in some very specific situations, it might be what you have. So we'd want to make sure that you allow yourselves the ability to use the documentation that's available in that situation. We would want the documentation, again, to be something that satisfies the conditions of that specific special circumstances. And so the type of documentation that you get would be very different depending on the type of situation that you're talking about. We want the information that you are obtaining to be adequate and reasonable. We certainly don't want to traumatize students as we're asking for additional information. We don't want to make it too difficult for them to prove their special circumstances if they have them. That said, we do, again, recommend that you use third-party documentation when possible. Ideally, there would be something on letterhead from someone who's professional to speak to the circumstances. Sometimes that might be something from a state agency. For example, unemployment benefits. It's fairly simple usually to get a letter from the unemployment agency in your state to document that situation. That said, other situations, for example, when a parent is not available, the situation I was referring to earlier, I had a student who said to me that her grandmother was raising her. She never knew who her father was, and her mother was a drug addict who would kind of come in and out of her life, and she couldn't find her at that point, couldn't get information from her. So her situation was very different than someone who could come in with a letter from an unemployment agency. And so we just want you to be sensitive to the needs of your students. We want you to counsel them in terms of what they should be obtaining for you so that they have a sense of what you need and they don't have to continually go back to people and get more and more and more. So we want you to retain that flexibility, again, for the sake of that student. That said, we want you to get the documentation that you think you need, so you shouldn't feel bullied if you have documentation and you don't think it's sufficient to prove what that person is asking for if they're requesting a review of special circumstances. Remember that professional judgment is entirely your option. That said, I've known some people who said, I don't think I ever want to do that. It's very scary. I don't want to have to worry that I have the right thing or don't. We would say use it as you feel you need to assist the students that you're serving to the best of your ability. So I would hope that people wouldn't be so frightened by the idea of professional judgment that they wouldn't do it if they felt it was warranted. It's there. It's in the law. You have discretion to use it as you feel appropriate. And we want you to make sure that you're using it, again, appropriately. And the documentation would be what satisfies that appropriateness. That measure is something that, yes, it's subject to a judgment, but if you have documentation in your files, I think that you'll find that people are pretty reasonable in reviewing that documentation. A school can refuse to do professional judgment. Again, I would hope that you would do that on a case-by-case basis, that you wouldn't just blanketly say, I'm never going to do professional judgment, or I'll never review for special circumstances. But you shouldn't feel that you have to do something just because somebody asks for it. And you certainly shouldn't feel obligated just because another institution has done professional judgment that you would have to carry that over at your institution. You're making your professional judgment or your interpretation of these special circumstances. So if you determine that the documentation that you're given isn't satisfactory, or the situation isn't one that you would entertain at your institution, you have every right to do that. We also want to remind you that you should have a policy in place. That policy should state when you do professional judgment, the types of documentation you're looking for, but allow yourself enough room if you get a situation you hadn't encountered previously that you are flexible in terms of what you're able to do. So rather than say, we must have 3 letters on third-party letterhead, you might ask for 3 pieces of documentation for situations where it's warranted. That might be where you're relying on third parties. But in some cases, 1 piece of documentation might be adequate, such as the example I gave earlier about unemployment. We also want to remind you how the processing part works with professional judgment and verification. Years ago, I presented a session on verification, and we were talking about the idea of professional judgment and verification being a 2-step process. So we said, if the student is selected for verification, you complete verification first, and then you decide, because then you'll have the information you need to see what the student's actual data would yield, you decide if you want to make an exception to it. So somebody came up to me at the end and said, 2-step process. Okay, so every time I want to do professional judgment, I have to verify. No, that's not what I said. Keep in mind, it's if a student is selected for verification, then it's a 2-step process. You are not required to verify everyone for whom you want to do professional judgment. That said, some people choose to do that, and you may always, as an institution, school select somebody for verification. So again, we're giving you flexibility. We're not requiring that of you, but if you choose to do it, then it would still be that same 2-step process. So you would never be able to do verification, send it back through the central processing system, and also do a professional judgment in the same day, because you need to wait for your results to come back for verification. Again, that's if they're selected, and keep in mind that selected could mean from the department, or it could mean from the institution. So if they're subject to verification requirements after you get those results, then you would use that transaction to make any adjustments that you've chosen to make. Cost of attendance adjustments. And I think I said earlier that Bruce would talk about this part, and this is still me. We also have the law quoted for you here, and again, while I don't typically read, I think this is important enough that it warrants going over. We talked about this earlier, the idea that nothing in this part shall be interpreted as limiting the authority of the financial aid administrator on the basis of adequate documentation to make adjustments on a case-by-case basis to the cost of attendance, to allow for the treatment of an individual eligible applicant with special circumstances. So this is that piece of talking about cost of attendance. The cost of attendance elements are set out in statute. And we would expect that for each item within cost of attendance, you would typically have some amount allocated for your students. Now, there are some, and we'll talk about that coming up, that are only as applicable, such as childcare expenses or disability expenses. But for the most part, the cost of attendance components are what they are, and it's to be an estimate of a student's expenses, or we talk about sometimes the budget that you establish for a student. So typically schools are using average costs. They're not going to say each person gets their own unique budget. Many times people, especially if you have numerous budgets, you'll group people into a category and say for students who are living in residential housing on campus, this is their budget. An off-campus budget maybe has some different expenses. But you'll use an average for students, and it might be within a specific program that the costs are different than other programs. You establish those budgets. You decide what is the right component that you're putting into those. But then you have the ability to make exceptions on a case-by-case basis. So here is the list of cost of attendance elements. We've broken them out to show you ones that are typically direct costs at many institutions. That would be items that are being paid directly to the institution, such as tuition and fees, books and supplies. In some cases, that could be room and board as well. Other expenses include transportation, miscellaneous personal expenses, dependent care, first-time licensure cost, if that applies to your students, as well as other costs associated with study abroad, again, if you offer that. Disability-related expenses. Those are items that apply to some students and not all. It could be that somebody asks you to adjust their cost of attendance, though, because they have unusually high expenses. If they have a disability and you've allotted a certain amount of money, but then they turn around and find out it's going to cost significantly more for the services that they need, you may end up doing a cost of attendance adjustment mid-year. Perhaps the service increased in cost, and so you wanted to make that adjustment so that they would be able to obtain additional aid to cover those expenses. Again, you will determine this based on your judgment. So somebody may say, well, I'm a first-year student, and you budgeted for a double room with a roommate, and I'm really struggling to get along with my roommate, and I would like to live alone, and a single room has come open. Will you do a cost of attendance adjustment for me? You have to decide if that's reasonable. You get to make that determination. That's one where you can come up at the end of the session and ask that question, what should I do? And that would be where we say, it depends. We can't answer that for you. You have to decide if that seems appropriate for your student. And again, it may be that for someone you say yes, and for someone else you say no, because as part of your discussion with them, you feel it's needed for one student, but not another. We often talk about doing things that are reasonable and that you would expect to see students treated similarly, that are in similar situations, but that when you interview the student, you might find that one has some disability, that they struggle to study in a room with someone else. And so maybe for that person you say yes, and the other person who just says, well, I grew up an only child and I never had a roommate and I'm not used to sharing, maybe for that person the answer is no. You decide that. We also talked earlier about the idea of EFC data elements. Here we're talking about making adjustments to the values of the data elements required to calculate the expected student or parent contribution or both to again allow for those special circumstances. So when you're adjusting EFC data elements, we're giving you the latitude to modify one or more data elements that are on the FAFSA that are used to calculate the expected family contribution. We want to remind you that it is very important that you look for something that applies appropriately. So if you're looking at the special circumstances, you want to make sure that you're adjusting something that's reasonable. So you wouldn't want to say, well, a person is unemployed, and so instead of looking at something that would relate to that, such as the income, I'm going to look at some other element. You would want to choose something that relates as closely as possible. We have some specific situations where we as the department have given guidance in the past, typically through Dear Colleague letters or other electronic announcements or questions and answers posted out to IFAP. And we would like to cover a few of those here today, just as a reminder. One that often comes to mind, especially in the last several years, it seems this has come up a lot, is IRA Roth conversions. If you have an individual retirement account and you have the more traditional type of IRA, that information, that income or that money that you have, I should say, would be taken out when you withdraw it, and it would be taxable. So the Roth was added later to your available options for retirement accounts, and when you withdraw a Roth IRA, that information is not taxed. People are allowed to convert their retirement accounts or their IRAs from a traditional to a Roth, but when you do that, the amount gets reflected on your tax return as taxable income in the year that you do the conversion. You really aren't earning any money, but it's a way of working through the IRS regulations, and we want people to understand that impact of that conversion on a student's EFC. So it will look like the person earned more income, and then again, their EFC would be higher. And it may be that that's the only thing that is keeping somebody from being eligible for a Pell Grant, for example. So a school can use professional judgment to adjust the income and the taxes as though that Roth conversion did not occur. Now, we encourage you to consider this if you wish to do that, but we are not requiring that you do it. We just want people to understand the impact of that conversion and what it could do to a family situation, that it will give you an anomaly in that year, and it's something that you can consider. For unemployment benefits, several years back in 2009, there were 2 Dear Colleague letters published about the use of professional judgment, and those 2 Dear Colleague letters touched on the idea of unemployment benefits. We also clarified a couple of years later in 2011 that those Dear Colleague letters were still in effect because we were getting a lot of questions. Now, we haven't published another Dear Colleague letter recently to let you know that those are still in effect, but they are. So the guidance that is in those initial letters can still be followed today, and it instructs you that you can reduce unemployment benefits to 0. And we consulted with the Department of Labor and also with the Office of Management and Budget, and the agencies got together and determined that that benefit would not have a significant impact on the EFC for an independent student. But if other family members are receiving those benefits, schools are encouraged to consider the family's economic situation. So for example, the parent of a dependent student, it may have a very serious impact on an EFC. And so you may want to consider removing and taking down to 0 the amount of unemployment benefits for someone who's unemployed. That said, some institutions wait until somebody has been unemployed for a certain period of time before they'll consider. Again, that is within your judgment, and as the statute says, nothing can limit your authority to do that. Letters for unemployment insurance, we mentioned earlier, come typically from the state unemployment agency, and we have given you guidance that you can use those for 90 days from the date of issue. Some agencies are very good about giving updated letters, other ones it is more difficult. But we do feel that that 3-month window of time is a reasonable amount of time to say that that letter is still valid. Other verification of unemployment benefits is still an acceptable substitute. Some people have shown the funds on a bank statement going in through an automatic transfer, as many of these, typically years ago we always thought of the unemployment check, and now many are using electronic funds transfer. So if you see that every week or every 2 weeks that money is going in from the state agency to the borrower or to the student or their parent, that is something that you could consider as an acceptable substitute for documentation purposes. And we just ask that schools try to determine if the student or the family member is still unemployed before they actually apply for the provision. And again, in some cases that could be a signed statement, that could be an interview that you have with that student or that parent. Typically, people like to get something in writing, and so the signed statement is often very useful for that type of purpose. We also wanted to touch on the idea of prior year data. This was certainly very newsworthy, I guess now a couple of years ago when we first started talking about going to prior year income data. And people were asking if applicants would have the option to use the prior year as opposed to prior year when they were filling out their FAFSA form. And so we wanted to clarify that no, when we decided to go to prior year, looking back 2 years, so from the example here, given 2017-18 FAFSA forms, you would be looking at the 2015 tax year data. And so we would not allow you to just go back 1 year now that we have shifted this. We would see that as circumventing the law because, again, this was a change that was made widespread, and we wouldn't want people deciding that for their students they were only going to go back 1 year. I think now that we're into prior year income, now that we're into it for more than a year, that question comes up less often, but we did want to remind people that that is out there and that that is guidance that we had given. We do believe that because of looking back that 2-year window, that there might be more opportunities for people to request the use of your judgment for special circumstances, because now that data is older, there could be more of a reason for change. And so, again, that change could go up or down in terms of the EFC. And we do want to remind you as well that you don't only have to do professional judgment in order to lower an EFC or to get somebody more eligibility. Sometimes if you look at the situation, you might choose not to do professional judgment because it doesn't have the impact that you expected it would have. But that, again, is your decision to make, and you do have discretion there. So while you can identify a category of students who have similar circumstances, remember what I said earlier, you're not able to do everything the same for all people in a category just because they seem to have the same situation apply. You would still need to get individual documentation for each one and document those on a case-by-case basis. When you are making your adjustments, people have often asked us about this idea of a 12-year period or looking back a year. How do you determine where that year starts? Is it an award year? Is it a calendar year? How do you do that? And we would say that it could be any of those. It could be prior year income data. It could be the past 12 months of income from the time they requested the information or made the request to you for special circumstances review. It could be any 12-month period that you've determined is reasonable for the circumstances that they're trying to present to you and for the documentation available that might be there for them. Certainly, if a student comes in and they say that their parent is unemployed, if they have a letter from the unemployment agency and it's within that 90-day window, but you say, well, I was going to do it based on these 12 months, but if I do it a little differently, I can still make this work. And rather than asking them to go to the agency and get another letter, you might want to consider what documentation they already have available. And if it's reasonable, that may be what helps to drive your decision in terms of where that window applies. And now I'm going to turn it over to Bruce for a discussion about income protection allowance as well as some other operational items related to professional judgment.
Okay, hello. Okay, let's talk a little bit about income protection allowance. Now, is what Annmarie indicated earlier, that you're given a tremendous amount of latitude in making these determinations to adjust the EFC data elements. But before you do that, and beyond what she had already shared with you, before you do that, make sure that one of the things that you're considering is not already included as a part of the EFC calculation. For those of us who understand the EFC calculation, we know that there's an element in there called the income protection allowance. Now, the income protection allowance is exactly what it sounds like. It's an allowance as a part of the formula. We actually subtract an amount of funds from the student's or parent's AGI, the adjusted gross income. Okay. Now, again, the key here is by understanding the actual calculation or the income protection allowance, it actually assists you in a tremendous way in making adjustments by understanding what we've already taken into consideration for reducing the parents or the family's AGI. Now, the key here is that you take a look. Yes, we have the formula that you can go through. You can look at the application verification guide, but that's no fun, right? What you want to do is you want to look at your ISER on page 3, and you'll find basically a value that's labeled IPA, which stands for Income Protection Allowance. Now, when you're looking at that value, and usually they're typically high, depending upon the family size and number in college, you're going to look at that and you're going to say, okay, let's say, for instance, it's $22,000. You can count on the fact that of that $22,000, 30%, we've already taken into consideration their cost for food. So you can say, listen, it was $20,000. We say 20% is food, so that means 30% is food. Wow, they're spending $6,000 a year for food, okay? And so you can break it down accordingly. Same thing here, 22% for housing, 9% for transportation, clothing, personal care, 11% for medical expenses. So we get very specific in taking into consideration certain things that it takes in order for the family to survive based on their family's financial strength for the year for particular expenses. So where this comes in handy in understanding this particular element is by knowing, for instance, that breakdown of those different percentages that I just talked about. We try to avoid examples because we want to give you the flexibility to make your own determination. But I did think it was important that we include an example for you right here. And that is, for instance, we go on page 3, we see the IPA is $7,780 for this particular family. Now, based on that, we know that 11% of that was accounted for medical expenses. So we could say 11% of $7,780, we said, okay, we expected that they spent approximately $856 in out-of-pocket expenses to cover medical expenses. And so if a student comes into your office and they say, listen, we spent $2,856 this year, we anticipate the same for this next upcoming year while I'm attending school, you can go ahead and look at that IPA and say, you know what, this does indeed exceed what we've already taken into consideration as to what they might spend in out-of-pocket medical expenses, and so you would adjust accordingly. In this case, we already know that we took into account $856, but there's $2,000 in addition to that that we can go ahead and subtract, literally, the AGI, subtract from the AGI the $2,000, or remember, taxes paid. That's an actual FAFSA element, because let's be honest, there is not an actual FAFSA element that we can change that we can change. There's no IPA that they actually fill out. So we actually have the option of either subtracting the AGI or increasing the taxes paid, because taxes paid is a direct allowance that is measured against the actual AGI. Okay, so you can do one of those two things and reduce it by the difference that we've not already taken into consideration. Now, a lot of schools often wonder, and we just included this here so that you would understand the differences between the two, or the kind of impact that it will have on a student, and that is, how is it that I can what is it that I can do, whether it be adjusting the cost of attendance or the EFC data element, by changing, for instance, the cost of attendance, how is that going to affect my student as opposed to making an adjustment on the EFC data elements? Because you're going to do either one or the other. So we decided to go through a little bit we decided to go through what would happen in the event that we made the adjustment to the cost of attendance. So generally, when making an upward adjustment on the cost of attendance, depending upon the student's circumstance, the intent here really is to potentially increase the student's need-based and need-based aid eligibility. Now, the truth of the matter is, if I have a student, for instance, that has that has received the maximum amount of financial aid, they have reached the total amount of aid that they can ever receive, meaning that I am not allowed to receive any more financial aid because I've already hit the cap on both my cost of attendance and my need, this is where you might want to consider increasing the actual cost of attendance as opposed to adjusting an EFC data element, okay? Because by increasing the cost of attendance, if I've already maxed out and hit my cap on cost of attendance, by increasing the cost of attendance, I may, as a result, make myself eligible for more financial aid. Okay. Now, sure, I get it that a part of the cost of attendance, a part of the Pell formula includes, right, the EFC and the cost of attendance. But because of the fact that cost of attendance really has an effect on the Pell formula because it is so low, what is it, 5580 at this particular point in time, 5,580. If your cost of attendance is not higher, if your cost of attendance is below 5,580, and it probably is not, then maybe that's something you want to consider. But we know that it typically does not have an effect on Pell eligibility, which is why we didn't include it here. So I'm going to give you an example here of what might happen in the event that we have a cost of attendance adjustment. So here we have basically all of our different cost of attendance elements here equaling a total sum of $16,300. Right? Notice my EFC of 7,200, and I have a remaining need. I have a need as a result of 9,100. And here we have a scholarship in the amount of my need-based aid. I have a scholarship for 7,500, and a direct loan sub of $1,600, because quite frankly, we're not allowed to exceed our need of $9,100. And then I have my non-need-based aid making up the difference of $7,200, so they are indeed receiving the maximum amount of financial aid up to their cost of attendance for $16,300. So here I go ahead and I make an adjustment to my cost of attendance by a difference of $1,700. Now that might, notice how we didn't go into the detail here because we don't tell you what you can or cannot do. You have that flexibility to make that determination. But we made a simple adjustment of $1,700 to upward adjustment of the cost of attendance. And as a result, my cost of attendance goes up to $18,000. Now, by increasing my cost of attendance upwards to $18,000, notice, of course, my EFC doesn't change. But because my EFC is still the same, but my cost of attendance is higher, my need does actually increase. So the result of my need increasing, I'm now eligible for more need-based aid. And in this case, I'm eligible for more direct loan subsidized aid, a subsidized direct loan. Okay. As a result, I've reduced the direct loan unsub aid, but I've also increased my plus. So notice how the difference here is that I've increased the amount of overall aid that my student is able to receive, even in this case, increasing the need-based aid in this case. Now, when I'm dealing an EFC data element, understand that, again, the intent here by adjusting the EFC data element is to lower the EFC to potentially increase Pell eligibility or other need-based aid. So in this particular case, I want you to notice that we have still a cost of attendance of $16,300. I have the amount of total financial aid that I'm receiving also equals $16,300. And so scholarship $7,500, direct loan sub of $2,800. Now this is a somewhat different student here, but notice my need here is $10,300. So in this case, I did make an adjustment to the EFC based on a data element, and the EFC went, again, from $6,000 down to $4,200. As a result of doing this, a couple of things have actually occurred. Before, I was not Pell eligible with an EFC of $6,000. So if I see a student who's right on the cusp of being Pell eligible, this is something that I might want to consider. Because I went from a student who was not Pell eligible to a student who is now Pell eligible to an EFC of $4,200. And because it was right on the cusp, but you'll find that it really does not take a significant difference in making an EFC data element for us to actually make them eligible for a significant amount of Pell funds. And so they went from receiving not only that scholarship, but now an additional amount of free money for $1,770 that I get to add on to my need-based aid, up to $12,100. So I not only gave them Pell, but I also increased my direct loan subsidized aid. But as a result, I want you to notice that my cost of attendance did not get adjusted. My student is still only eligible for $16,300 in this particular case. And so as a result, my student did not get any more aid, but in this case, my student did get more free money and more subsidized direct loan funds. Now, that doesn't mean that all of my students have maxed out on the total amount of aid, meaning that I've already reached my limit. We all know that that doesn't happen on a regular basis. I just want you to measure the differences between the two. If I have a student, for instance, who is not maxed out on the total amount of aid that they can receive, meaning they've capped up to their cost of attendance, I might want to consider adjusting their EFC because it doesn't mean that I'm going to get necessarily more money in financial aid because I've already maxed out the amount that they can get. Maybe in this case, I do want to adjust the EFC because now, in addition to the aid that I've already maxed out on, I can also give them on top of that Pell Grant funds. So in that case, I might get additional money. The idea is for you to make that determination based on the student's particular circumstance and weigh that circumstance against which of these two approaches you want to make for the student. So the next thing I want to get into is I want to talk to you a little bit about the dependency override. Now something interesting happens here in that notice that I'm looking at part 480D7. This is not the same part that Annmarie was reading earlier. This is entirely, it's actually the very next section. And it states this. It states that a student who does not qualify as an independent student in one or more of the 13 categories as defined in Step 3 of the FAFSA may be considered an independent student if he or she is a student for whom a financial aid administrator makes a determination of independence by reason of other, notice we went from special circumstances to unusual circumstances. So I want to point out to you, this is the one instance. Notice how we're talking about making sure, for instance, completing the verification ahead of time. This is one instance where we have a dependency override, where you can actually make this determination as part of them even completing the application process. You can actually make that as a part of the process, and when they initially submit the application, if you want to, there's a section both on the FAFSA as well as if you want to go ahead and enter it in through FAA Access to CPS Online, where as a part of the initial application process, you can go ahead and give them that dependency override. Or you can make this determination subsequent to them completing the application process. Now again, I just want to point out to you that we did talk about this, and this goes all the way back where we actually gave some clarifying guidance to you in Dear Colleague Letter, notice Gen 03 back in 2003 of 07. We wanted to be clear, because there were some schools when we initially talked about this, certainly in the 90s, that were actually, let's just say that they were not using it in accordance with the intent of the law. And so we wanted to make sure that, that when they were making this determination that, that it did merit unusual circumstance. And so in Gen 0307, we provided for you examples where we're very clear and very explicit in saying that these things do not merit unusual circumstance where you're able to provide for them a dependency override. And again, this all going all the way back to Gen 0307 that still applies today. Okay, number one, parents refusing to contribute to the student's education. We do not consider that as being a circumstance in which you can go ahead and provide for them a dependency override, nor them being unwilling to provide information on the application or for verification. Now this sounds kind of familiar because we actually ended up addressing this in 2009, a little bit later on. But up until that time, if they basically said that we don't care, we're not going to provide for them any support, and we're not going to fill out the application, we said, well, then you're not going to get any financial aid at all. Okay, and this is what we had said, certainly up until that time that we made dispensation for in 2009, and I'll talk about that in just a little bit. But again, also parents. Now this goes way back to, I think, 1992, where the parents who were not claiming the student as a dependent for income for tax purposes, that we're allowed to make, we said that they were independent as a result of that, and that has not been the case since, like I said, I think it was 1992, since we changed our position on that. Also, students demonstrating total self-sufficiency. I'm sure we hear that quite a bit from our students, right? But that is not a reason for you to provide for them dependency override. Also, parents live separately from students in a foreign country. Okay, so long as they're still in good contact with them, they certainly can provide support for them. And so that is neither a reason for them for you to provide for them a dependency override. And by the way, that was added as a result of Gen 11, 2015. Now again, this does not negate the fact that, negate what we have said always prior to Gen 0307, which is that we certainly recognize an unusual circumstance could absolutely include an abusive family environment, something we're all familiar with, or an abandonment by parents. So certainly use those if you feel that it warrants a dependency override. I do also want to point out to you Gen 11-15. For those of you who want to look at other examples, we actually published this Dear Colleague letter with other examples that we thought merited dependency override that you may not have considered, okay? And notice it talks about relating to a family crisis or unlawful act, for instance. I think one of the examples is maybe the parent is a criminal or has been caught committing fraud on some level, and that student does not want to be a part of that environment where they themselves might also be caught, or they themselves want to involve themselves in that particular person's life who is committing some sort of fraud, and so they have a relationship where they don't want to pursue them for information and completing that information for them. And so as a result, they don't want to involve themselves with their parents, okay, who are committing unlawful acts. Sorry, I kind of rambled on that, but I apologize for it. And so you might want to consider that particular student, give them a dependency override, because we have evidence of the fact that they might commit fraud or some sort of unlawful act. Anyway, what I want to point out here is notice that we didn't put up the examples, because again, it's the department, we're prohibited from telling you what you can or cannot do in these circumstances. But we did want to provide you some examples where you might take into consideration. Okay, so again, notice how we had the parent's refusal to complete FAFSA and provide support. Again, going back to Part 479A. And by the way, this was added later on, okay, back in 2009, I believe it was. And it says that in addition to again, saying earlier, in this title shall be interpreted as limiting the authority of the student financial aid administrator to offer dependent student financial assistance under Section 428H or a federal direct unsubsidized loan without requiring the parents of such student to file the financial aid form prescribed under Sections 482 if the student financial aid administrator verifies that the parent or parents of such student have ended financial support of such student or refused to file such form. Okay, forget that. Let's just talk about what it's saying here, okay? So essentially what it's saying is prior to introducing to this new category, as I indicated earlier of PJ, a student whose parents refuse to complete both the FAFSA and refuse to provide financial support, again, they would be ineligible to receive any kind of Title IV aid before. Now, with this new provision in place, the school can now exercise professional judgment and make the student in this situation eligible for a dependent student level unsubsidized direct loan only. Now again, the key here is notice how we're saying that they're eligible to receive an unsubsidized direct loan. Notice how this is not serving as a dependency override. Because their parents are refusing to complete the FAFSA and refusing to provide support does not make them an independent student. They're still a dependent student. They're just eligible for unsubsidized loan funds only on a dependent student level. So for instance, for grade level 1, we know that the annual loan limit, both the base amount plus the additional and sub combined, is going to be $5,500. The entire amount is going to be unsubsidized loan funds, and that is it. Now, the interesting thing to note here is that a non-custodial parent, meaning that I have a parent who is listed on the FAFSA as is required in accordance with the instructions that we provide for the student, they're the ones who are saying that I'm not going to complete the FAFSA and I'm not going to provide any kind of financial support. Now, if I have the non-custodial parent who says that's okay, I will be the one that will provide for you a plus loan. Guess what? They're allowed to do that, and it does not show, as a result of it not being the non-custodial parent, they're still going to be eligible for that $5,500 in unsubsidized loan funds. Okay, now, that non-custodial parent, because they're not listed on the FAFSA, that's not going to change. Okay, but they can still take out the plus loan, and they can still receive the $5,500 so long as it's the non-custodial parent who's taking out the plus. Obviously, if it is the custodial parent who's taking out the plus loan, that's a problem, isn't it? Because they're providing financial support, aren't they? And so that would prohibit them from doing that. Okay? So again, keep in mind, sometimes we have these parents who are unwilling to provide even that statement. And that's okay, that they're unwilling to provide support as well as complete the FAFSA. You can go ahead and circumvent that by pursuing a third party to provide for you some sort of written documentation indicating that that's the case. Okay? Now let's get to this next part, and I'm going to read this, okay? Let's be honest. But this, I want you to notice how you notice how we were talking about earlier about professional judgment, that we do not have regulations for professional judgment. And the truth of the matter is this was written prior to the law that we had in for for Part 479. So this was already in place for quite some time, which is 34 CFR 685.301. And basically what it says is this, is that you have the ability to make the determination to deny or reduce a student's direct loans. Now, the key here is that if you're going to do that, you need to make sure that you have the reason, that the reason is documented, and you provide your reason to the student as to why you're denying them or reducing their direct loan. Okay, so if you're going to say no, you're going to have to make sure that you let the student know why you're saying no, and you provide that for them in writing. You provide that for them in writing. Now, there's a trick here to that now, though, or isn't there? Sure, we can do that for any type of direct loan, whether it be subsidized or unsubsidized or a plus loan. Sorry, just looking at this real quick. So keep in mind here that it's not only just, there are a lot of schools out there who'd like the opportunity to go ahead and deny students loans. And what I like to say to schools is sometimes we have students who will say something, and you catch them saying something that is, well, not on the up and up, and you may only have one person that heard them say that. A lot of schools are under the false impression that maybe I need to have a second witness, and so they try to get somebody else to come in the room to hear them say, hey, could you say that again, so I have some sort of second witness in order for that to occur. I'm just letting you know ahead of time that that's not something you actually have to do, okay, that you do that. But again, the key here is that you document that you, as to the reason why you've done that. Now again, the idea is not only to reduce it, to deny them that, or even just to reduce it to the amount that maybe you might cover just institutional costs. Now again, the denial reduction can be done if this is done on a case-by-case basis. Unfortunately, we catch too many schools who try to create a category of students because of maybe the program that they're in, or the risk that it might propose to the schools in increasing their default rate. And so as a result, they end up doing this for a certain group of students to reduce that risk. You can't do that. Again, this has to be done on a case-by-case basis. Also, just like I indicated earlier, you're going to have to provide that reason to the student in writing. And make sure you return that, make sure that you maintain that documentation, that supporting documentation in the student's file. Now, the key here is that if you're going to do this also, you're going to, number one, provide it to them in writing, but also make sure that if you're going to do this, be very careful that it does not in any way engage in any pattern or practice that results in the denial of a borrower's access to direct loan because of the borrower's race, gender, color, religion, national origin, age, disability status, or income. So I want you to be very careful with this, that if you're going to deny them that this is not something that you're actually practicing here, okay? Now that is essentially professional judgment. Now we did approach this from the ED's perspective because again, you have a tremendous amount of latitude and flexibility in order for you to make these determinations. But we wanted to show for you, I apologize, let's go over the resources for you really quick before we start taking questions. Again, you can find, it's relatively small, it's basically a 4-page chapter on professional judgment found on Chapter 5 of the Application and Verification Guide. The only federal regulation that I talked about, which is the one I just told, it can be found at 685-301 and denying or reducing direct loans. And of course, you have the Higher Education Act 479 and 480. And these are all the Dear Colleague letters that we provide on clarifying guidance as they pertain to professional judgment. So at this time, I think it'd be a good opportunity. Now keep in mind that if you have a very unique special circumstance at your particular school, that's great. Maybe you want to talk to us about that separately, but of course, feel free to come up to any one of the microphones otherwise and let us know about any questions that you may have about professional judgment.
Thank you for doing this session. I appreciate it. I come from a graduate school, so we have PhD and master's students. My question is, my PhD students are fully funded, but some of them will be married with unemployed spouses, not actually unemployed, like as far as losing a position, but just decides not to work to take care of their children because it saves them money. Is there any way we can help that family? Because our PhDs are not receiving any federal loan programs at all. They're completely being paid.
So you're telling me that you have a cost of attendance, and that they've received up to the total sum of the cost of attendance.
And usually the stipend goes beyond. So they're usually over the cost of attendance by about $2,000 with scholarships, health insurance awards, and stipend. So they're not eligible for any federal aid at all. But I get the question a lot from our PhD students with families that they can't afford to live on the stipend that we provide to them, and they want to exercise, fill out the FSA and get some federal loan programs.
I do think I want to, and I hate saying this just as much as Annmarie, and saying that it depends on the circumstance that is happening here. Remember, there are certain things that occur even with the cost of attendance, and that's something also that we're not allowed to provide regulatory guidance on, as it pertains to cost of attendance as well. So it really is a broad question that I don't think that we're allowed to even venture into and saying yes or no. Again, this is why we give you the latitude to make that determination on your end. Are you going to increase the cost of attendance based on, do they have unusual circumstances? Remember, the idea of cost of attendance is to cover everything from, like I said, medical expenses to eating pizza on Friday nights for those 9 months in which they're attending school at your school, and that's the intent for it. But are there special circumstances that warrant an increased cost of attendance that might give you the opportunity to increase the amount of financial aid they might
That's what we
need?
thought of, like rent, for example. If we put into our cost of attendance budget, I don't know, $1,000, and their rent is actually $2,000. Do you see that as an adequate increase that we can use that as documentation?
Yes.
I think for something like rent, for example, I mean, you're setting your cost of attendance.
Right.
And we say that we want it to be something that's reasonable. If you find that an entire group of students is coming to you saying what you're giving as cost of attendance isn't reasonable to live off of, then you may want to take a look at what you're assigning for your amounts for cost of attendance and see, is this reasonable? How you do that varies. Some people do a rent survey of their current
we did that
students.
this year.
Some people look in, local listings or talk with other people at other institutions nearby and see what they're using. But it may be that you want to reevaluate what your numbers are, because, people will often complain about, well, we want to limit loans. And I'll say, really? Because they'll say, well, the borrower, they have too much. They don't need all of that. Well, this is the converse of that. And I always say to both sides, you're the one setting up your amounts. You set what is reasonable. But if you have so many people coming to you saying, I can't live off of this, then it may be that that's your approach, and then they would have eligibility if you change what your budget is.
Okay.
And that's not a professional judgment. That's you making that
So
determination.
you could technically have a budget for master's students different from your PhD.
You certainly
Then
could.
Can you downgrade your PhDs to different budgets, like tier them down, like a family of one budget would be this, family of two? Or is that too much?
I think some of it, again, it depends. You want to look at, like, I wouldn't, if you have your students and they're living in the same type of housing, I don't think it would be reasonable to say, well, for the master students, we're allotting $1,000 a month, but for a PhD student, we're charging $2,000 a month.
Right.
Because remember, it's really the students' living expenses that we're covering. We're covering what does it cost for them to go to school, not so much to raise an entire family.
Right.
That said, some people would say, well, that's a lifestyle choice that somebody doesn't work. Other people would say, well, it's not reasonable for them to work, depending on the program that the student is in, and maybe childcare isn't available around the clock in your community, but yet the student has to go to medical clinicals 24 hours a day.
Right.
Like, there are things that will say it depends, and not as a cop-out, but to really say you have to look at your population and you know them better than we do.
Right, and dig deeper. You never know
Yeah.
what's underneath. All right, thank you.
Thank you. We're going to go over to microphone 1.
Hi. I have a hopefully quick question about the idea of carrying forward from year to year. And I will preface this by saying we do currently require students to resubmit everything every year, but sitting here thinking about this is how I came up with this question. We will occasionally have students who will sign a year-long lease that will be over our cost of attendance. And so we'll do a cost of attendance appeal to allow for that increased rent allowance. Would we be able to use that same lease for both years if we required the student to submit in both aid years the request for an appeal increase? Or would we need them to resubmit to us the same lease that we already have on file?
No, you wouldn't need to resubmit the same documentation if it's truly the same, and especially with crossovers and different academic calendars, we wouldn't expect you to get another copy of something that you already have. But in that case, the documentation that you're getting for you to reconsider includes their appeal again. So
Right.
you are making another determination.
Yes.
And that's certainly fine.
Perfect.
Yeah, and notice how we don't get into that kind of minutia, and there's a reason why we don't do it. You don't want us telling you
Yes.
what to do in that case, right?
Thank you.
I always say this is almost like a gift that we give you. Often we're very prescriptive about you must do this, you must do that. So when we give you the latitude, I think sometimes people are so used to us being so very prescriptive that it makes them uncomfortable with the idea that you have latitude. But we always say, don't ask us to be more prescriptive, because I don't think you want that. And we don't want that. So we're going to go ahead over to microphone 3 and then back to 2.
Hi, can you elaborate a little bit more on why verification must be completed before a PJ is done?
Sure. We want to make sure that you're doing, if somebody is selected by either us or the school, we want to make sure that you are making professional judgment based on the best data that we have available. So if you're getting in tax return information that yields a very different EFC, we want you to use that starting point. And then we kind of want an audit trail. We want to be able to look at that data and see, what is that professional judgment made from? So if you hadn't made the adjustment, let's say there's $20,000 in income difference once you've done verification, that affects an EFC significantly. So we want to get a sense of what's going on when professional judgments are being made, what information is changing, and what is your determination versus what would have been done from the tax return anyway. So it helps us to kind of get a sense of the changes and how widespread the changes are, and a lot of it is really just to make sure that you have that right starting point.
So I have a couple examples where I feel like it would be extra work on the administrator, where maybe there's a death or a divorce, and it seems to be pointless to include the other person's tax information in that verification at that time. Yeah. And then you have to remember to go back the next day to remove that deceased person or divorced person's information.
Right, but that's the key. We want to make sure we have an accurate picture prior to the special circumstance. And so as a result of the person having passed away, we first have the initial, and then we have the initial amount, what the circumstance was prior to the death of that particular individual. And as a result of now having an accurate picture, what is the difference going to be as a result of removing that particular individual's income?
Okay, thanks.
Yeah.
Number 2?
Okay, good afternoon. I just wanted some clarification on adjusting a one-time disbursement. If the disbursement comes in multiple phases, give me some clarification on that. When I think of one time, I'm thinking of a one-time disbursement, but not multiple disbursements and calling that a one-time disbursement. What's your opinion on that?
I'm not sure I understand. I'm not following either. Okay, so you have.
So let's say I had a gambling debt. Okay, and I won $50,000. That's one time. That's probably not going to happen again.
When we hear disbursement, we think about the school giving the student money. That's why I think we're through.
Okay, I'm sorry.
No, that's okay.
That's okay.
Sorry.
I'm glad you
To me-
clarified
Thank you
it.
for
To me, that's a disbursement too. That's money in the pocket. But at any rate, so that $50,000 comes and it's a one-time deal and we take it away. But then that person keeps winning. Or
First, I'll say I'm jealous.
Or let's say they're removing money from IRA or 401k. They make a disbursement, call that a one-time.
Right.
But then they go back 2 or 3 more times and make disbursements as well. Can you keep making adjustments per disbursement?
Yeah, go ahead.
You can. Again, that's your judgment. Some people would say they wouldn't entertain it the first time because that money is available to that family to use, and that some of it should be used for educational purposes. Again, that's your call. and then you have to decide what is the reasonableness. If you did it based on a determination that this was a one-time situation, for example, somebody might say, well, you know, I made a large withdrawal and then I used it on these medical expenses, so I don't have it available to me. And then the next year they came back and they said, well, I had additional expenses. I think it's your discussion with the family that helps you to decide what is reasonable or not. But we wouldn't say just because you're doing it multiple times that it's incorrect.
So I guess the clarification I need is, so I get the professional judgment appeal, and when I get it, it's called a one-time disbursement, but the documentation shows multiple, I'm still using the term disbursements, multiple payouts. So you're saying that's okay? That can still be called a one-time?
Yeah, we're going to have to end it, but let's be clear. Notice how we're walking on a tightrope here, because we're not going to tell you whether or not you can't do it. And I think that's what Annmarie's trying to tell you, that you can make that determination based on whatever you think is best for the student and best illustrates the family's financial strength for this particular award year. That's the best thing that we can do in telling you yes or no. But we're not going to say yes or no in this particular case.
Okay.
Okay, does that make sense?
Well, it makes sense.
Yeah.
Thank you.
Sorry.
Thank you.
Our time is up. We apologize. But that doesn't mean you cannot see us afterwards. I do know that I'm going to do a session next door right away. But keep in mind, I'll be at the Ask a Fed desk as well. Come and see me anytime and ask me any more professional judgment questions.
And I'll be up here in the front row up until we start the next open session, but they need to get the room turned over for the next one. We are offering this session 2 additional times, and we will be available again for questions. Our email addresses are probably the easiest way to get to us. So thank you again for attending, and we hope that you found this to be helpful.